Welcome back to Court TV Live. I'm Michael Ayala. We have breaking news for you out of Minnesota today. The state Supreme Court has reversed the murder conviction of a former police officer who shot and killed a woman after answering a 911 call. Now, the court said that Mohamed Noor should never have been charged with third-degree murder in the death of Justine Rucksack, an Australian woman who called police to report a possible sexual assault behind her home. I want you to take a listen to some of the arguments by Noor's attorney and from the assistant Hennepin County attorney made in June in front of the Minnesota Supreme Court.
For more than a century and in at least 20 separate opinions, this court has recognized that depraved mind murder cannot occur when a defendant's conduct is directed at a particular person. This court has solidified the particular person prohibition's role in depraved mind murder in its last three opinions analyzing the crime: State v. Zumberg, State v. Hall, and State v. Coleman. As those three opinions demonstrate, the particular person prohibition is relevant to whether a defendant acts with a depraved mind. It must not be conflated with the separate and distinct issues of whether a defendant acts with intent to kill or even intent to harm. This court's particular person prohibition is consistent with the statutory text, with the common law, and furthers sound public policy considerations. This court does not lightly overrule its precedent, and it should not do so here. Since Mr. Noor's single shot was directed with particularity at Ms. Rucksack, the particular person he observed outside his partner's squad car window, his conviction for third-degree murder cannot stand.
It seems like you're arguing that if it's aimed at one person in particular, that's kind of the ball game, and it's not third-degree murder.
Your Honor, because that's what this court has held for over 100 years and in 20 separate decisions. And I think it is, it's important to emphasize, I don't know that the Court of Appeals fully grappled with this, that the particular person prohibition has been the sole deciding factor in multiple cases from this court. I mean, I think it was in Lowe itself. I also think most recently in some of the lesser included offense cases, you cannot read those cases in any other way other than that the particular person prohibition was the deciding factor. Specifically, I direct the court to State v. Harris, a 2006 opinion that we cite in footnote 6 of our principal brief. And in that case, this court said, the defendant could have been acting without intent to kill, but nonetheless, because the conduct was directed at a particular person, because he shot someone in the back, by definition, we're concluding that no rational jury could conclude that this individual acted with a depraved mind, given the way in which we have construed that statute for over 100 years. And I think the same is true in State v. Zumberg, where this court even assumed that perhaps the defendant didn't even intend to harm the person whom he shot, but because that shot was directed with particularity, it came outside of the definition of depravity. And I really do think that makes sense if you go back to Derry and think about what is the category at common law of depraved mind murder that was attempted to be encompassed within that statute. And it is these indiscriminate murders where a person is so depraved, they don't care whether they kill one person or another.
If you maintain that a person cannot be convicted of third-degree murder if they act if their actions are directed at a particular person, there is not going to be an officer-involved shooting that can be prosecuted under Minnesota's depraved mind murder statute. There isn't. They are all directed with particularity. And I think that actually demonstrates the flaw in Noor's argument. Again, it's inconsistent with common law. It's inconsistent with the statutory text. It's inconsistent with the expressed intent of Professor Pertig, who's the drafter of the 1963 code, which is our current statutory version of depraved mind murder.
Now, Noor has been serving a 12.5-year sentence for the third-degree murder conviction. He was also found guilty of second-degree manslaughter, but was not sentenced for that charge. Manslaughter holds a 10-year maximum. Now, his case will now go back to the lower court, where he will be sentenced on that second-degree manslaughter conviction. Now, Noor has already served more than 28 months, and he could go home by the end of this year based on time served. So this reversal could also impact the cases of Derek Chauvin and the other 3 former Minnesota police officers accused in the death of George Floyd. The third-degree conviction could be vacated against Chauvin, and the pending third-degree murder charges against the other 3 officers could be dropped. Of course, we'll keep you updated on those developments as they come into our newsroom. Right now, I want to bring in Julia Janae. She stands by again. She's been covering this case. She's our Chauvin expert. She knows everything about it. So I want to bring her in. Also want to bring in criminal defense attorney Silva Megadichian. Julia, let me start with you. I want to get some context for this ruling. As I mentioned, this could have an effect on the other cases that we've been following, the Chauvin case and the cases against the other 3 officers. Tell us about that.
Right, it could have an impact on Derek Chauvin's conviction when he appeals all of those charges that he was convicted on, including third-degree murder. But also the 3 other officers who were with him, they have a third-degree murder charge pending as well. And we heard about this during the trial that happened many months ago. There was a question of what will happen with Mohamed Noor's case because we knew the Court of Appeals ruled that the third-degree murder charge stood, that even though it was directed at a particular person, we just heard those arguments, that it still was qualified for this particular case. But because it's been reversed and those cases, Chauvin's, Toutow's, J. Alexander King and Thomas Lane's are all going forward, that calls into question whether or not Derek Chauvin's third-degree murder charge can be appealed successfully, because this is now the binding ruling from the Supreme Court. This is the High Court of the state of Minnesota, and they are saying that if there is a particular person who the crime is directed at, it does not qualify for third-degree murder.
And again, solving the issue that there have been a number of courts with different interpretations over that third-degree murder charge and what it actually means. I want to call up a quick full screen here and read you the definition as it exists. Whoever, without intent to effect the death of any person, causes the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life shall be guilty of third-degree murder. Silva, I want to bring you in. I can be honest with you here. When this charge was introduced in the Chauvin trial, that's when I sort of first became familiar with it, as we hadn't been following the Noor case that closely. I wasn't sure that it would apply to instances like this. When I read it, the letter of the law sounds like it really applies to cases that are a bit different than when there's one individual being targeted. It more sort of applied to folks when they shoot into a crowd or drive a car into a crowd. I want to get your thoughts.
Absolutely right, Michael. In fact, I believe I was on your show when we were discussing this. I actually did not think he was going to get charged with it. I actually said on camera, it's a stretch, and that the district attorneys usually will throw so many charges at clients, hoping that one will stick, but not in this case, because the language is essential. Generalized indifference to human life. Noor's attorney said it the proper way. You cannot target an individual with specificity and then say there's a general disregard. And your hypothetical is absolutely correct. Think of, shooting a gun indiscriminately outside of a car. Or if Derek Chauvin, while he had that knee on the neck of Floyd, decided to take out his gun and wave it in the crowd, and it accidentally discharges to keep control, there's an argument there. But when you're focused on one person, it's such a stretch. I was in shock even that it went as far as it did. So I do suspect it's going to be overturned. And I also do suspect that the 3 other officers won't get that charge either.
Yeah, I have to agree with you there. And Julia, you know what's interesting about that? I can remember when we were discussing the Chauvin case, that third-degree murder charge really sat as what we thought might be a compromise, because it had more significant penalties than the manslaughter. And if you couldn't get the second-degree conviction, you could rely on a significant penalty with the third degree. But you heard the state say, with this ruling, we're probably never going to see a charge of third-degree murder against police again.
Right. If the court has now ruled that this is basically the traditional interpretation of third-degree murder and they're not going to expand what it means, that would make it where you wouldn't have a third-degree murder charge, which is that lower-level murder charge in Minnesota. But that doesn't mean there aren't other options. Derek Chauvin was convicted of second-degree unintentional murder, so a much more severe charge than the third-degree murder, but he also had the second-degree manslaughter, which Mohamed Noor was also convicted of. So now his case will focus on that, and he could go on supervised release very soon.
All right. Well, I want to thank you both, Silva Megadichian and Julia Janae, for your insights.